Hello, everybody. Welcome. We're so pleased to welcome you all to Debra Dowd's presentation on the immigration process, Immigration 101, Life After F-1. This webinar is hosted by the Office of International Programs and Services and Debra Dowd, an experienced immigration attorney from Dowd Company PC. Debra will cover questions related to post-graduation immigration issues such as OPT, H-1B, other employment visas, and the green card process. Alexandra Melikova, an F-1 advisor from OIPS, will also be available during the presentation for questions related to F-1 OPT and STEM OPT. Debra and Alexandra will answer your questions related to the presentation at the end. If you have detailed F-1 employment questions, we suggest you join us next week for the OIPS Career Conference on September 21st, with sessions starting at 9:30 a.m. We just have a couple of important points about the presentation today. As a participant, you won't see other participants in the meeting. You will see the presenter and hosts. You will also be able to see the screen being shared at the moment. We will use the Q&A feature today for questions. You can type your questions in the Q&A box, and Debra or an advisor will answer after the presentation. For the webinar, the chat feature will be disabled for the participants, but may be used by the host or presenter to include an important link or point during the presentation. We would like to ask for your patience as we manage any potential issues with the agenda or technology. And we thank you all for being here. And now time for Debra Dowd. Thank you.
Good morning, and thank you for the introduction. Good morning, everyone. I'm happy to be here today to talk with you about life after F from an immigration perspective. What we'll be focusing on will be a couple of points. Basically an overview of the U.S. immigration system, some quick points on COVID, some very quick points on F-1 employment, and then we'll get into sort of the immigration options for you after F-1 status. And that presentation section will include an overview of the non-immigrant or temporary visas available to you like H-1B, and also the immigrant visa options available to you, such as family-based green card, employment-based green card, things of that nature. So we will proceed at this time with a quick overview of the immigration system. Historically, the goals of the U.S. immigration system have been fourfold: to encourage investment in the U.S., to promote family unity, to solve workforce shortages, and to promote the best and the brightest in the arts, sciences, business, and athletics to joining us here in the U.S. Some of these goals are evident in the U.S. Visa processes, and some are woefully lost in an incredibly broken system. So we'll kind of talk through that as well. The government agencies that we deal with in the U.S. immigration system include the Department of Homeland Security, and within the DHS, we have the Citizenship and Immigration Services, ICE, Immigration and Customs Enforcement, and the Border and Transportation Security, or the Customs and Border Patrol, as we more commonly know them. We also deal with the U.S. Department of Labor and the state workforce agencies. We deal with the U.S. Department of State. And in really dire cases, we deal with the Department of Justice, the Executive Office of Immigration Review, which is essentially immigration court. So that's the bad part. We don't want to talk about that. In terms of terminology, we talk about immigrants and non-immigrants. Immigrants are those with green card. Their green card status is permanent. There are family-based petitions, employment-based petitions, and once you have a green card, there's no limitation on your activities or the length of time you spend here. In terms of non-immigrants, these are all temporary visa status. We refer to it as alphabet soup because they're all lettered by A through V at the time, W at the time. So you'll hear H-1B, L-1, E, O, F, M, all of those different letters denote non-immigrant or temporary visas. Most of them are centered around tourism, education, and employment activities. And each one of those temporary visas carries with it limitations on your activities and limitations on your length of stay. In terms of who the players are in the immigration world, you'll hear us use terminology such as petitioner or sponsor. That is usually the employer who's sponsoring or the qualifying family member who's sponsoring someone else for an immigration benefit. You'll hear the phrases beneficiary or principal. This is the individual being sponsored for an immigration benefit. And you'll hear the word derivatives, and those are the qualifying family members of the principal who join the principal, typically spouse and unmarried minor children. For immigration purposes, minor children are those who are under 21. So let's talk real quickly about COVID. Everyone has COVID questions in terms of how COVID is impacting immigration. It's impacting it in any number of ways. For immigration benefits on the US side, the processing times are woefully slow. They've doubled and tripled and quadrupled in some cases. Immigration benefits outside the US at the consular posts are also very, very slow, or in some cases non-existent at this time. We're dealing with embassy closures, reduced staff at the embassy, appointment availability is very sparse. So the immigration benefit side has been significantly impacted by COVID because offices are closing down and there's a shortage of staff. In terms of travel, the US does have a COVID testing requirement for entry into the US. Those requirements can change on a dime. So you need to, if you're going to be traveling outside the US or planning to travel into the US, you need to be following on a daily basis the COVID requirements in terms of testing, as well as travel restrictions to the US. The US has no restrictions on you leaving the US, but there are certainly restrictions on who may enter the US. I've given you a link to one of the best sources for following those travel restrictions. There are certainly a lot of sites out there right now that are talking about the COVID restrictions and purporting to give you good information on that. Feel free to check those, but always go back and check the Department of State link that I've given you here. That is the official site. I'm not telling you not to go to other sites. I'm just telling you to back it up with what's on the U.S. Department of State site for confirmation. And check it regularly. If you're planning on leaving and taking a 2-week trip, you should be checking that site every day because it can change while you are out. So the rules that existed when you left may not be the rules that exist when you're trying to come back. Presently, there are the primary restriction is 33 countries are impacted by a travel ban to the US, even with a negative COVID test. You may not enter the US if you've been within one of these 33 countries in the last 14 days prior to entry. So there are some exceptions to the rules, and those exceptions are listed here. F-1s are exempt from that restriction right now. And there are others that are exempt from the restrictions as well. Those that are subject to the restrictions can request what we call an NIE, a national interest exemption to the restriction to allow them to return. And those that don't qualify for a national interest exemption, the only way for them to get here would be to leave one of those 33 countries, travel to a country that is not on the list, spend 14 days in that other country, and then enter from that other country. So that's how we have some folks getting around it, but it's not easy and it's certainly not inexpensive. So in terms of COVID, be aware of it, be cautious. We are counseling our clients at the moment that if they do not really have to travel, to try to avoid travel outside the US, because we cannot assure anyone that we will be able to get them back due to COVID restrictions. All right, so let's talk about your F-1 status. I understand that most of the folks on this video are F-1 academic students, and I want to encourage you to make close friends with your folks online here. They are your best source of information and material in order to ensure that you comply with your F-1 status. So the next slide has just a few links that I found to their services, their office and their services, and they have really good information on their site. So if you are an F-1 student, you should be familiar with this site. You should be checking it regularly. They have quite a few offerings in the way of seminars, presentations, materials to guide you through different processes and steps. And what I will say is that though they do a tremendous job, it is not their job to ensure your compliance. We hear from a lot of F-1 students who have done something to fall out of compliance with their F-1 status, and I always hear, I didn't know. And what I can tell you is, if you're paying attention and if you are visiting their site and staying in touch with them, you will know what the rules are, and it is incumbent upon you to maintain your F-1 status, because falling out of status and trying to get reinstatement is very challenging, and certainly not guaranteed. So I'm going to jump back to the F-1 student employment opportunities. F-1 students generally are prohibited from employment in F-1 status, with 3 exceptions. You may work on campus for up to 20 hours per week. You may apply for and be approved for CPT, which is Curriculum Practical Training. CPT is generally think of it in terms of an internship or an externship that is part of your course of study. It needs to be an integral part of your course of study. It needs to be approved as part of your study. And that would all go through your international office there at GMU. And OPT is optional practical training. It is the work authorization that allows you to work outside of the university and outside of your course of study with private employers. You usually reserve this for when you've completed your course of study. There are circumstances in which someone might use it during their course of study, but use the CPT option if you can for that. It's a better option for you. The OPT is used after graduation normally, and it allows you to work for 1 year. And if you're graduating from a qualifying STEM program, an additional 2 years with OPT, and it really gives you a great opportunity to get out into the workforce, develop a relationship with an employer, and hope that that employer might down the road sponsor you for an H-1B visa or another qualifying visa to allow you to remain in the U.S. to work, if that is your interest. So in terms of the qualifications for CPT, on-campus employment, CPT, OPT, again, I'm going to direct you to the OIPS website and just a wide range of very detailed information available to you on all 3 of those topics. And I know they also hold office hours that allow you to schedule an appointment and go in and talk with them. And I encourage you to do so. So I'm going to kind of leave here with the F-1 information, because there are some additional programs GMU is sponsoring coming up on this. And I'm going to spend my time today on what happens after F. So we're going to start with the non-immigrant visas, or the temporary visas. The non-immigrant visas are typically employer-sponsored visas. And if they're sponsored by an employer, we refer to them as an employer-specific visa. And that means that when an employer sponsors you for a visa status, you can only work for that employer. So if employer A sponsors you for a job for an H-1B visa, you cannot get H-1B visa with employer A and go and moonlight with employer B. They are employer specific, and you may only use that approval to work for your sponsoring employer. So we will touch quickly because we don't have a lot of time today. It feels like a lot of time, but there's a lot of information here. So we'll touch quickly on each of these employment-based non-immigrant visas. These are the most common visas that you may look to after F status, and you should be looking toward them during F status so you can plan ahead. But the most likely scenario is you'll go from F1 to F1 OPT and then move on to one of these types of visa status if you desire to remain in the US. There are other paths to remaining in the US and having an other status. These are not necessarily employment sponsored, but they are options that you can consider in rare circumstances. Asylum, refugee, temporary protected status, DACA, deferred action, and then adjustment of status applicants. So these are much more rare, so we will not spend time on them today. But if you have questions about them, you can post your question in the chat box and we can try and address it at the end. So let's start with the H-1B visa. The H-1B visa is the most common visa used by F-1 students as they're approaching the end of their OPT. The H-1 visa, again, is employment-based. It is employer-specific. It is reserved for people who are going to be offered employment in a specialty occupation. A specialty occupation is defined generally as an occupation that requires at least a 4-year degree in a field of study directly related to the job. So by way of example, if you are going to get a job as a chemist, you need to have a degree in chemistry or something very closely related to chemistry. If you are just a chemistry whiz, but you have a degree in English literature, you're not going to get an H-1B visa because your degree in English literature is not closely related to the job being offered. For the H-1B, there is no requirement that the employer advertise the job. There's no recruitment requirement. There's no requirement that the employer show that this is a hard to fill position or that they could not locate a qualified U.S. worker for the job. All of those things, advertising, recruitment, hard to fill, no qualified U.S. worker, are related to the green card process, but people often confuse them with the H-1B process. The H-1B visa is, though, subject to what we call a labor condition application. We refer to it as an LCA. And I think this is why people get sometimes the requirements for the H-1B confused with the requirements for the green card, because the green card process has a step called labor certification. And labor condition is very closely sounding to labor certification. But the labor condition application, the LCA, is only part of the H-1B. No recruitment required. And the LCA is a process by which the employer submits a job to the Department of Labor to confirm that the wage being offered in the H-1B case is an appropriate wage for the H-1B job in the geographic region in which the employee will work. So that's what the labor condition application is that really quick 7-day wage process for the H-1B. You probably have heard about a cap or a limitation on the number of H-1Bs available. There is a limited number of H-1B visas issued each fiscal year. The government's fiscal year runs October 1 through September 30th. There are cap subject employers and cap exempt employers. Most of your private employers, in fact, nearly all of your private employers are going to be cap subject employers. If the employer that's offering you an H-1B position is cap subject, then you have to go through the H-1B lottery and be pulled in the lottery, selected in the lottery, in order for the H-1B process to go forward for you. The H-1B lottery occurs each March. Historically, the H-1B lottery process was different, but the past couple of years we've had a new lottery registration process. So this is the process I will describe to you today. Basically, the employer has to register the H-1B electronically in the database in March when the window opens. The window will open, and we don't know the dates yet for this coming March, but it will be announced, and we'll typically have about a 10 to 15-day window to register cases in the lottery. Once the lottery registration closes, we will then start to see selection notifications be issued in that registration system. So the cap gives us each year 20,000 H-1B visas for those holding a U.S. master's degree or higher. It must be a U.S. degree and it must be a master's or higher, and you must have the degree earned by the time we register or file for the H-1B. If the degree must come from an accredited U.S. institution, if you do file under the master's quota, your case will be considered under both the master's quota and the regular quota. The regular quota is 60,000, and those are for anyone with at least a bachelor's degree from anywhere in the world. It's not U.S. based when you're qualifying under the regular cap. In addition to the regular cap and the master's cap, we have 6,800 visa slots available for individuals from Chile and Singapore. I'm sorry, I think I said 60,000, it's 65,000 for the regular H-1B lottery cap. So 20,000 US masters, 6,800 for Chile and Singapore, at 65,000 for the regular cap. If you are being offered employment from an exempt employer, you don't have to go through the lottery. Your exempt employer will simply file the H-1B any time of year, anytime it's necessary. Exempt employers are colleges and universities, and university affiliated not-for-profit entities like teaching hospitals and things like that. In addition, nonprofit research institutions can qualify as a cap exempt employer. Exempt individuals, those individuals who are exempt from H-1B lottery process include those who've already been counted in the lottery, and those who are employed at a cap exempt work site, even though your employer may not be cap exempt. And those physicians who are here in J1, changing from J1 to H-1B, also do not have to go through the lottery. There is such a thing as concurrent H-1B employment, so you can have and hold 2 approved H-1Bs at the same time, working for 2 H-1B employers. If you are seeking concurrent employment, you have to make sure that the second H-1B is filed properly, so it doesn't replace your original H-1B. You need to make sure it's filed as a concurrent H-1B so that you don't lose that first one. We go back to the lottery just a bit. So in terms of the lottery registration in March, it's a very quick process. Basically what we ask for in terms of filing the registration is a copy of the job description, a statement as to the wage offered. We ask for the individual's credentials, such as their diplomas, transcripts, passport, so that we can do a quick check to make sure we think that if we get selected in the lottery, that we have a good shot at getting the H-1B itself approved. We are hesitant to take up a lottery slot with a case that we know or can predict will not be approved. That example I gave you with respect to a job in chemistry with a degree in English literature, we would advise the employer not to submit that registration into the lottery cap because it is highly, highly unlikely to be approved if we're selected and we file the H-1B. That said, it's up to an employer if they wish to file in the lottery. You may only submit for the same person and the same job one time in the registration. You cannot flood the registration system with multiple entries for the same job, same person. If they catch it and see it, they will delete all of the registrations. You'll have no opportunity to be selected in the lottery. And as I said, the lottery registration process itself is very simple. We handle those for our employer clients in early March. We gather up all the information so that when the registration opens, we're ready to submit. As long as you are submitted within the open window, it does not matter if you're submitted first or last or in the middle. Everyone who's in that registration will be considered once they start to run that electronic lottery. If you're selected in the lottery, we get an email notification. We go back into the registration system. We see the selection. We print the selection. And then we have a period of time after selection during which we must file the full H-1B petition package with the USCIS. So that's how the lottery works and the filing works. The case still must be approved. So if you're selected in the lottery, that's not a guarantee. We strongly advise you to continue to maintain your underlying status, which is likely F-1 with OPT. Continue to maintain your status. If you have a STEM extension available to you, we strongly recommend you apply timely for all extensions available to you. Until your H-1B approval notice is in your hand, you need to take care of your current F-1 OPT status as if you weren't going to get the H-1B. For those that have the STEM extension available to them, it's essentially 3 years of OPT. We do encourage you to consider applying in the H-1B registration for the lottery early because you may not be selected. Generally, there's about a 1 in 3 chance of selection in the lottery. It's all based upon the number of people who apply as compared to the number of slots available. But historically, we've been seeing about a 1 in 3 chance of selection. So if you're If you have the STEM extension available and you apply in year 1 and you're not selected, you can apply in year 2. And if you're not selected, you have that third bite at the apple. If you wait until the end of your OPT time and you're not selected, there's really very little anyone can do to keep you here working in that job. You may decide to go back to school and continue your education, but you're maintaining F-1 status at that point. But there are very few options if you're not selected in the lottery. That's not to say there are none. Some people have more than others, but as a general rule, the options absent H-1B are slim. Okay. So quick note on H-1B extensions. If you actually get your H-1B and you're in H-1B status, we recommend filing the extension for your H-1B 4 to 6 months in advance of the expiration. You may not file more than 6 months in advance. The H-1B is available to you for a maximum of 6 years. So we recommend when you have H-1B status that you track your travel outside the U.S., keep a travel log the date you left the U.S., the date you returned to the U.S., and keep records of your plane tickets, travel itinerary, things of that nature, so that you can prove the time out. The 6 years is counted by the days you spend in the U.S. The days that you spend out of the U.S. are days that are what we call recapture days. We can add those on to the end. You can extend your H-1B beyond 6 years if your green card case has moved forward fast enough, far enough, before you run out of H-1B time. So there are 2 rules for extending H-1B beyond 6 years. The first one is if labor certification is filed prior to the 5th anniversary of your H-1B status and it remains pending. And the second is if your I-140 petition is approved prior to the 6th anniversary. Those 2 items, labor certification and I-140, are the first and second stages of green card, and we'll cover those more extensively a little bit down the road. Everyone wants to know about H-1B costs. These are the current costs for your H-1B. H-1B fees must be paid by the employer. And you have government fees. There's a base fee of $460. There's a fraud fee of $500. There's a supplemental fee of $1,500. Not all employers are subject to that supplemental fee. And if you're a small employer, that supplemental fee is only $750. If you're a company with more than 50 employees and more than 50% of your employees are in H or L status, then there's a border security fee of $4,000. Very few employers are subject to that border security fee. It's a rare event. And then the premium processing fee, which is optional, is $2,500. The employer does not have to pay the premium processing fee. When I work with my employer clients and they ask me, Deborah, is premium processing necessary? And I'll evaluate the case. And if there's a business need to pay the $2,500 premium processing fee, I'll advise the employer to do it. They don't have to, but I'll advise them to. If it's not necessary, but the employee really, really wants it done quickly, the employee may pay that premium processing fee. Okay, we're going to move on to the O visa. The O visa is also available to those after F, but it's going to be a small percentage of people who qualify for the O visa, particularly after bachelor's degree. It's more common after master's and certainly more common after PhD. But it's for individuals with extraordinary ability in the sciences, education, business, athletics, and arts. Extraordinary ability is someone who's risen to the top of their field. We prove it by showing any number of factors. We can prove it by showing that they have a national or international honor or award like a Nobel Prize. Most people don't have that. So there's also a menu that we can choose by showing that the individual qualifies for 3 of the items off of this menu. So often when I talk to folks, they'll say, well, I'm a member in an association, so I meet item 2B right here. I've published, so I meet item 2C. And I'm employed by a prominent organization that needs my work. So someone will come to me and say, well, I have 3 of these, so I'm entitled to an O visa. But that's the first step in the analysis. So the standard is that we must show that you have sustained national or international acclaim or recognition in your field. We can show that by showing that you meet at least 3 of these criteria, but it's not a single step test. It's not show me 3 and therefore you have sustained national and international acclaim. It's show me at least 3 that demonstrate you have achieved national or international acclaim. So you have to be very careful about what you read online and stuff. And there are a lot of websites out there that say, if you have 3, then you automatically get O1. Not true. It's if you have at least 3 that demonstrate national or international acclaim in your field, that show you've risen to the top of your field, then you can apply for O status. And there are different standards if you're in science, education, business, athletics versus in the arts. And it all means the same thing. It's just if you're working in the arts, the documents you're going to present are going to be different. You may not have published, but you may have displayed your work, things of that nature. Okay, the J visa is a cultural exchange visitor visa. There are many categories within J. You'll see them listed to the right there: au pairs, camp counselors, students, interns, physicians, professors, research scholars. Some of these are more common than others. If you've ever been down to the beach during the summertime, you will see a lot of J's there who are here for summer work travel and things like that. If you go to the ski resorts in the winter, you might see a lot of J's working there under one of these categories. I myself have had 2 au pairs when my children were small, and they came in on their J's. The thing I will warn you about with respect to the J, it looks wonderful, and it looks like for some of you who are coming out of F status that you might get a job and be sponsored in J status for one of these categories, but be careful. First of all, not all employers, very few employers are J sponsors. To be a J sponsor, an employer has to register with the U.S. Department of State as a J sponsor. They have to jump through quite a few hoops, file an application, pay annual fees. So many private employers are not going to be J sponsors. Most of your J sponsors are going to be your colleges, your universities, and then there are a lot of organizations out there that serve as J sponsors and will sponsor your J visa and place you at different places for some of these programs. You can go online to the USCIS website and find a list of the J sponsors and see if any of those might work for you in the future. Be careful also because some of the J visas will carry with it what we call a 2-year home residency requirement. You'll hear it referred to as 212E. That's actually the section of the law, the Immigration and Nationality Act, section 212E. Provides that certain J visa holders are subject to a requirement that they go home for 2 years before they are eligible to change status to H-1B, change status to green card. Even if that J visa holder marries a U.S. citizen, if they're subject to that 2-year home residency requirement, they may not get their green card until they have either satisfied the 2 years or applied for and been awarded a waiver of the 2-year requirement. So be careful before you accept J1 to know whether or not you will become subject to the 2-year home residency requirement. That could interrupt future immigration plans. The TN visa, think of it as Treaty NAFTA. It was created under the NAFTA Treaty. It's available for Canadian citizens and Mexican citizens. It is think of it in terms of a mini H-1B. Unlike the H-1B, which defines a specialty occupation fairly generically, the TN visa is available for a list of very specific jobs, very specific occupations. You can follow this list if you're Canadian or Mexican. You can follow this list for a list of the occupations that can be sponsored in TN. The TN is a great option for Canadians and Mexicans because it's very quick and easy and inexpensive to get. You can get it year-round. There's no limitation on the number. There's no lottery. There's no particular wage requirement like the H-1B carries. So the TN is a great option, but it definitely is limited to Canadian and Mexican citizens. The E-visa is for those who are seeking a visa under a treaty trader or treaty investor status. So we deal more with treaty investors. Treaty trader certainly exists, and basically the treaty trader side of things requires that you be sponsored to work for a U.S. employer that engages in sufficient trade with an entity abroad. And the government will measure the trade and make sure the trade qualifies for the E1 treaty trader. E2 treaty investor is much more common. It is an investment-based visa. You will also hear about an investment-based option for green card. Don't confuse the two, they're very different. The treaty trader E2 visa is, first of all, it's based upon there being a treaty between the US and your home country. You can go to the link I've provided and see if your country is on the list. If you see your country on the list, check it to see if it's listed for both E1 and E2 or just one or the other, because it can be one or the other or it can be both. You must be a national of that treaty country, and the company itself must also be a national of that treaty country. So I recently had an Italian company call me up. They wanted to sponsor one of the Afghan refugees to come over on an e-visa to work for them here in the US. And it does not work because the individuals being sent over or offered jobs in e-status must have the same nationality as the company abroad, the affiliated entity abroad. An individual may invest in their own company. So if you wanted to invest and start up your own company, you could, as long as your country is on the list. You can invest into an existing business, or you can invest into a brand new business that you're going to own. The ownership requirements require that you own at least 50% of the U.S. business, and it requires an investment with a three-part test. The investment must be substantial, non-marginal, and active. So active is a really easy definition. If you have a business open and operating, it's an active business. If you buy a piece of land and wait for it to go up in value to sell it, that is a passive investment. So it must be an active investment. It must be non-marginal. You must be able to show that the business plan shows the company will grow sufficiently to employ others beyond you and your family members. And a substantial investment is somewhat relative. So if you are going to be a 50% owner in a new ethnic restaurant and it takes $100,000 to open that restaurant, then your investment for a 50% interest must be $50,000. If you are seeking a 50% interest in the next nuclear power plant, a $50,000 investment would not be deemed substantial into that nuclear power plant because it would take much more than that to get that plant up and running. So it's a relative test to the needs of the business. That said, the law doesn't specify a minimum number for the investment, but we typically don't see approvals until the investment hits at least 50,000. We prefer 100,000. The investment can be from your savings. It can be from the sale of your assets. The money can come from a loan as long as you're personally responsible to repay the loan. So the E2, E1 is a decent option for a small number of people who are interested in opening their own business or investing in a business and have the financial wherewithal to do so. The L visa is an intra-company transfer visa. So if you have worked for a company abroad as an employee for at least 1 year, that company can transfer you to its U.S. operations. So as you're looking for employment opportunities, if it's not panning out here in the U.S. for sponsored employment opportunity, you might look to companies abroad that have operations both abroad and here. In order to qualify, you must be serving abroad in a position that is either managerial, executive, or specialized advanced knowledge. So specialized knowledge under the L is not the same as a specialty occupation under H. Under H, a specialty occupation is an occupation that requires at least a 4-year degree in a field related to the job. Under L, specialized knowledge is knowledge that you have gained working for that company during that 1-year period that you could not have gained out on the streets. So if, for example, if you are a specialist and very, very proficient in Oracle or Java, and you want to be transferred to the US, based on that, you will not be approved because you could learn Oracle and Java anywhere, at any company, at any employer. Specialized knowledge is that knowledge you would gain only within that company, whether it's their processes, their products, their pricing, their manufacturing, technology, something about that company that you could only gain there. And that's why there's a requirement that you have 1 year of employment abroad in one of these roles in order to transfer that knowledge to their US operations. There's no particular wage requirement. There's no labor condition application, no recruitment requirements, anything like that. We have to simply show that the two entities are closely affiliated in terms of ownership and that you qualify in that role abroad for 1 year and that you'll be transferred to a role here that's similarly qualified, managerial, executive, or specialized knowledge. The E3 visa is for Australian nationals only. It is a streamlined H-1B, not subject to H-1B lottery. It is subject to the labor condition application process, that wage requirement, but it can be processed directly at the U.S. consular post outside the U.S. There's no U.S. filing required for the E3 visa. So it's a quick and easy H-1B basically for Australian nationals only. Okay, that kind of summarizes the temporary visa options available to you. I know that there were quite a few. I know we went fairly quickly. This is intended to give you that overview so that you can start to explore your own facts and circumstances and figure out what opportunities you might have and then explore those options more deeply. So let's talk about the immigrant visa, which is the green card, the permanent visa. There are multiple ways to get to green card. You can get there through employment-based sponsorship, family-based sponsorship, self-petitioning, asylum and refugee, and then special legislation. I am not certain why my screen changed, but we'll go with it anyway. In terms of we're going to spend our time today talking about the employment-based options. I also put some family-based information at the end of this slide presentation, which will be made available to you so that you'll have some family-based information as well. If we have a few moments, I'll go over the family-based stuff, but if not, there's some information there for you. I'm also going to cover the self-petitioning options. I'm not covering asylum and refugee and special legislation, but I'll give you a quick rundown here. So asylum and refugee are basically the same thing. It's showing that you have a credible fear of persecution from your home country based upon an impermissible factor such as race, religion, political activity, certain beliefs, gender identity, things of that nature. And that you have to show that you have a credible fear of your government in your home country. The only difference between asylum and refugee is where the person is standing when they apply for it. Asylees apply from within the U.S. Refugees apply outside the U.S. and are admitted into the U.S. in refugee status after their analysis and the grant of refugee status. So they're basically the same thing. And then there's special legislation. Periodically, there are special laws passed to benefit special interest groups, giving them a quicker or easier or an open path to green card where no other path exists for special circumstances. So you've heard a lot on the news about the special immigrant visa that is available to those who aided our military personnel in Afghanistan. And there are many, many applicants coming over right now from Afghanistan and trying to come over from Afghanistan as a special immigrant visa process. Another example is after the breakup of the Soviet Union, we had the Soviet Scientists Act that allowed Soviet nuclear scientists to have a quick path to green card. We wanted to get them here quickly and then basically pick their brains and see what they knew about the Soviets' nuclear capabilities. So just two examples of special legislation that exists for certain special interest groups, which would apply to very few people, but for those it does apply to, it's very helpful. Okay, let's start on the employment-based preferences. So in the employment-based arena, the government breaks the cases down into 5 different preference categories. EB1 for employment-based 1, EB2, 3, 4, and 5. So I'm going to start at the bottom and work my way up a little bit. EB5 is the employment creation visa, also an investment-based visa. I mentioned during our discussion on the e-visa that you would hear about the investment-based green card process. This is it. The EB5 program, there's a lot of information online about it. It's wrought with problems and issues at the moment, but it is an option. But the investment in the EB5 green card case is a minimum of 500,000 or $1 million. Those numbers are scheduled to go up. And the investment must result in the creation of at least 10 US jobs. So that's really all I'm going to spend on that because it's such a narrow field. And if you think you have an interest in it, we can certainly talk offline about that. EB4 special immigrants are those special cases we talked about, the Soviet nuclear scientists, the special immigrant visas for the Afghans helping the US military. And there are some other categories that fall into there as well. Special immigrant juvenile visas and things like that, religious workers. So we'll, if you have questions about that specifically, we can also chat afterward about that. So most everybody who's being sponsored by their employer is going to fall into EB1, EB2, or EB3. EB1 has 3 subcategories: people with extraordinary ability, outstanding professors and researchers, and multinational managers and executives. The multinational managers and executives are, think about an ExxonMobil transferring their managers and executives around the world. That kind of category, but we do this kind of visa with smaller companies as well. You don't have to be an ExxonMobil size to take advantage of this visa process. Outstanding professors and researchers are exactly what it sounds like, typically sponsored by either research institutions or colleges and universities. And then extraordinary ability is a pretty wide category, also very similar to like the O visa that we talked about. You have to show sustained national and international reputation in your field, that you've risen to the top of your field. The EB2 preference category includes people with advanced degrees, that's a master's and above. It does not have to be a US master's for this process. And people with exceptional ability in the sciences, arts, business, and athletics. There's also what we call an NIW, a national interest waiver process under EB2, and we'll talk about that in a few minutes. And then everyone else falls into that EB3 category for professionals, those holding a bachelor's degree or above, sponsored in a job that requires that degree, skilled workers, and other workers. So most folks will fall within EB3, and then as you move up the line, there's a smaller number of people who would qualify for EB2 and EB1. The basic employment-based green card process is 3 steps. Labor certification is the first step. This is not to be confused with the labor condition application that we file on the H-1B. The labor certification process is the process by which the U.S. employer tests the U.S. marketplace. The employer must show that it recruited and advertised and could not find a minimally qualified, willing U.S. worker for the job. So for this process, we have to very carefully define the job's minimum hiring requirements. We have to run advertisements. And if at the end of the day, the employer can look the government in the eye and say, we found no minimally qualified, willing U.S. worker, then we submit the labor certification case to the U.S. Department of Labor. We wait for processing, and if it's certified, we then move on to stage 2, which is the I-140 petition, that second column. The petition is filed by the employer with the USCIS, and basically think of this as the employer saying to the government, we've gone through labor certification, now please set aside a green card for my foreign-born employee. At this stage, the employer has to show it has the financial ability to pay the wage that was offered back in stage 1. And the employee has to show that he or she possesses the skills, qualifications, education, experience that we claimed back in stage 1 were the minimum hiring requirements. And you must have possessed those items at the time you were hired for the job. You could not have gained them in the job that you're being sponsored for. And then the third stage is called adjustment of status if you're in the United States. If you're processing from outside of the United States, the same process, adjustment of status, is called consular processing and is handled at the U.S. consular post. So the adjustment of status is basically the employee saying to the government, please give me the green card that was set aside for me by my employer. Some cases will have a waiting period in between. So in terms of timelines, the labor certification process takes approximately 6 months to prepare for filing, to draft the case, to get a wage request from the U.S. Department of Labor, to go through advertising and recruiting. It takes about 6 months, 4 to 6 months to get that labor certification ready for filing, assuming we pass that market test. If we advertise and we find qualified U.S. workers, we stop. We do not submit the case. We cannot because we didn't pass the recruitment test. We have to set everything aside and we can try again after 6 months passes. But there's no way to ensure that an employer will pass that market test. There are factors that we can review. If it's an easily filled job, then you're unlikely to pass the market test. If it's a hard to fill job, you have a good shot at passing that market test. But it's not something that's within the control of counsel or within the control of the employer. It truly is a test, and we have to see if we can get through that test successfully. So 4 to 6 months to prepare it for filing. Once it's filed, it takes approximately 6 months to hear back from the Department of Labor. So stage 1, that labor certification stage, you should plan on a 10 to 12 month process for that. It's not quick. There's no premium processing available for it. If successful, we move on to stage 2, really quick to prepare, takes about 2 weeks to prepare the petition. We file it, and the government processing time is usually 6 to 9 months. You can premium process the petition. There's often not a benefit to doing so, but sometimes there is, and we'll evaluate that on a case-by-case basis as to whether premium processing would be helpful at that stage 2, the petition stage. And then the adjustment of status is also fairly quick to prepare, a couple of weeks. We file it, and the adjustment of status processing time right now, if you look online, is ranging between about 12 months and 36 months. In our experience, the cases are not taking 36 months, even under COVID, but they are taking about 12 months under COVID. Some people will experience a waiting period in between stages 2 and 3. And the reason for that is that by law, there are only a certain number of green cards issued each fiscal year in, where did my numbers go? In each of these categories. So EB1 may have 100,000 green cards allocated to it each fiscal year. EB2 may have 75,000. And I'm making up numbers just because I want to use nice round numbers for easy math. EB3 may have 50,000 allocated to it. The numbers are not that, just examples. So within each category, those numbers are then further down, broken down into a quota system by country of nationality. So for example, if EB1 has 100,000 green cards available to it each fiscal year, the quota system may allocate only 20,000 of those to China or 15,000 of those to India. Again, just giving example numbers. So when we get here, if there are more people applying for green card in a particular category from a particular country than there are green cards available to give out, there'll be a waiting period in between the petition and the adjustment stage. Each month, the government issues to us a visa bulletin that tells us where we are in the quota system. So this is the visa bulletin for October of 2021. It tells us, if you look at this left column right here, it tells us that in the EB1 first category, the first EB1, if you go across the line, you're going to see a C all the way across the line. That C means it's current. That means there's no waiting time in between these two stages. And therefore, when we get to the petition stage, we could concurrently file the adjustment and the petition together because there is no waiting period. If we look at EB2, for China, you'll see the date July 1, 2018. What that means is that for those individuals from China in the EB2 category, the date is July 1, 2018. The first stage of their case, the labor certification, or in those cases where we skip labor certification and start with the petition, whatever the first stage of their case is, must have been filed on or before July 1, 2018, in order for them to move forward now with their adjustment of status, their third stage. So if you look at this and just take the numbers forward, this person, EB2 China, with a green card case filed today, would have approximately a little over a 3-year wait to get to adjustment of status. So during that waiting period, the person must maintain their underlying status, whether it's F1, H1B, L, E, whatever it is, they must continue to properly maintain status so that when their case becomes current under the visa bulletin, they can then file their adjustment of status. If you fall out of status, then you're not eligible to apply for adjustment of status in the US. You would have to go home to consular process, and certain periods of being out of status in the US could bar the green card process for 3 years. It could bar it for 10 years. It could also bar temporary visas like the H-1B as well. So maintaining your underlying status is critical at all times. So this is the visa bulletin final action chart. And a few years ago, the government in the visa bulletin, and you can subscribe to this visa bulletin if you go to the visa bulletin at the U.S. Department of State website. And there are lots and lots of others that post the visa bulletin, but they're taking it from the Department of State website. I recommend you go to the Department of State website if you want to subscribe to it. Don't go to another site. Go to the official site. It's travel.gov. And you can scroll all the way down, open one of the visa bulletins, scroll all the way down, and at the bottom you'll see the email address to email them to subscribe to the visa bulletin. So the visa bulletin, when you open it, there'll be a section on family-based cases, there'll be a section on employment-based cases, and for each of those, you'll see this final action chart. And then you will also see dates for filing chart, final action, and then dates for filing. So 2 charts for employment-based cases, 2 charts for family-based cases. The difference is that the dates for filing chart gives people an early opportunity to file before their case is actually current under the final action chart. So under the dates for filing chart, you'll see China's at September 1 of July 18. Not going to make much of a difference for them, but sometimes there's a pretty significant differential. So right here, if you look at India, EB2, the dates for filing chart is at July 8th, 2012. And under the final action, it's a year behind in September of 2011. So sometimes the dates for filing chart will give people an early opportunity to file. Filing under the dates for filing chart alone is a 2-step analysis. I've got the information here for you to go over that. Basically, if you see your case current here, then you go to this site and see if the government tells us we're allowed to use the dates for filing chart. Each and every month they tell us whether this chart is active or inactive. Some months it's only final action, some months it's both. And I know that's complicated and not easy to understand. And if anyone has questions about that, you can certainly post your question and we can address it at the end. So the first stage of the employment-based permanent residency process is that labor certification. I've described it already in terms of filing to show that you were unable to locate a minimally qualified willing U.S. worker. Here are a few more details. The purpose of it is to protect the U.S. workforce and ensure that we're not giving away green cards to fill jobs that could be filled by U.S. workers. By law, the employer must pay all costs associated with this first stage of the green card case. After that, for the petition stage and the adjustment stage, the government does not mandate who pays. The employee may pay, the employer may pay, there may be some combination. Government doesn't care, but the labor certification stage must be paid by the employer and the employer alone, without reimbursement, without a reduction in pay, things of that nature. In terms of the recruitment required, it's very, very specific. We don't get to fudge it. The government tells us Basically what we have to do, we have to post internally for 10 days. We have to place a job order with in Virginia, it's the Virginia Employment Commission. If there's in-house media, we must use that. We must run 2 Sunday print ads in the newspaper. And in addition, we have to pick 3 of these and do these as well. So we usually work that out with the employer. The employee that's being sponsored does not get to participate in the recruitment stage. That would taint the recruitment, so the employee does not participate. For the I-140 petition, that's the second stage. It is the employer's petition. It does not convey status to you. So even if we finally get your I-140 petition approved, that approval of the I-140 does not give you anything. It's just a step in the process. It doesn't allow you to remain in the US. It does not give you authorization to work. It may give you some benefits, like if you're an H-1B holder and your spouse is in H-4 status, getting the approved I-140 would allow your H-4 spouse to apply for work authorization. Getting the I-140 petition approved would allow you to extend your H-1B beyond that maximum of 6 years that we talked about briefly before. So it does give you some benefits, but it doesn't give you a status to enable you to stay. It doesn't convey authorization to work. The adjustment of status stage, that last stage, you can file it when you're current under the visa bulletin, as we've mentioned. Your derivative family members join you at this time, so your spouse and your unmarried minor children would join you. Children are children who are under the age of 21. There are some circumstances when a child who's over the age of 21 still qualifies under the Child Status Protection Act. That's a individualized analysis that we have to go through based upon the dates of filing certain cases and how long certain things took to process. So there's no blanket or generic answer I can give you as to how that works in any particular case without seeing very specific details. You must maintain your status up through the date of filing the adjustment of status. After that, you can let your underlying status go. We like to do that analysis. We don't give a blanket authorization to everyone to let their status go, but there are some circumstances that we review and evaluate, and we'll get comfortable and advise a particular client that it's time they can let their H-1B go. They don't have to renew it, or they don't have to renew their L, because under the adjustment of status, you are permitted to remain in the US while the adjustment of status is pending. The adjustment of status package that we file includes an application for work authorization. You cannot work on that authorization until it's in your hand. So we wouldn't, for instance, necessarily want an H-1B holder to let their H-1B go until that work authorization was in hand, or you would have a gap in employment eligibility. So when the adjustment of status is approved, that means your green card is approved and in your hand. So the adjustment of status does convey some benefits, unlike the I-140 petition, but it's still an individual analysis. People look at the immigration processes as being pretty generic, and while there are certain processes to follow in each case is very, very fact specific, and each case must be evaluated and analyzed on its own merits. So don't take any of this as generic advice that's going to apply to you. It really, really is very, very fact specific, and I don't want you running off and doing something without talking to immigration counsel before you make a hard decision about filing, not filing, or anything like that. And then I mentioned self-petitioning. There are some cases where you can avoid the labor certification. And in doing so, you avoid the sponsorship requirement. So it becomes a self-sponsoring case. So self-sponsoring cases include extraordinary ability and national interest waiver. Other cases that still require a sponsor but can avoid labor certification are what we call Schedule A cases and outstanding researcher professor. So let's start with the self-sponsoring cases. Self-sponsoring cases are extraordinary ability petitions, the EB-1A cases, where you have to show that you have risen to the top of your field and that you have sustained national or international reputation in your field. You do that by showing you have at least one major national or international award, like the Nobel Prize, or you have a series of other criteria that evidence sustained national or international acclaim. National interest waiver petition is another option. Basically, that is saying to the government that you work in a field of study, a field that it has intrinsic value to the United States, and that it would be in the nation's interest to waive the labor certification process for you. Both the extraordinary ability and the national interest waiver, or NIW cases, are self-sponsoring. They're the only two self-sponsoring. The other two, Schedule 8 cases and outstanding researcher professor cases, still require an employer sponsor, but they are skipping labor certification. So Schedule 8 cases are those cases where the government has pre-certified a shortage of US workers in a field. The two fields that we have right now are physical therapists and nurses. So nurses and physical therapists may jump to the petition stage, skips labor certification, and process their green card on a streamlined basis. Not that it's still quick, but it's quicker than going through labor certification. And likewise, outstanding researcher professor petitions are sponsored by their university typically, or their research institute, and we have to show that they too have outstanding credentials and are recognized by their peers as being at the top of their field, but it is a sponsored case. So that kind of wraps up the employment side. We have a little bit of time left. Noelle, you know how many questions are out there. Do you think I should go into the family-based stuff or start to answer questions?
We have 7 questions in the queue. I don't know if that is, would you want to do a little bit of the family-based, or do you think
on a little bit of the family stuff, and I'll reserve about 10 minutes for those questions.
Okay.
Okay. Okay.
Sounds good.
So again, you're being inundated with information today. There's a lot to absorb. But again, just want to touch on all these for you so that you can start your thought processes and move your thoughts forward on your own. So family can sponsor family. And in the US, immediate relatives are the spouses and minor unmarried children of US citizens, USCs. And then below that line, we have family-based preference categories. And there's a difference between being above the line and below the line. Above the line, you're not subject to those annual limitations on the number of visas. There's no visa bulletin that you have to look at. Immediate relatives can file for their spouses and minor unmarried children of US citizens at any time without regard to any numbers. Below the line, just like in the employment-based arena, the family-based cases are broken down into 4 preference categories. Family-based are FB1, 2, 3, and 4. And I've identified what those categories are. FB1s are unmarried adult children of US citizens. 2s have 2 subcategories. Family-based 2A are spouses and unmarried minor children of legal permanent residents or green card holders. And FB2B is unmarried adult children of legal permanent residents. FB3, married children of US citizens, and FB4, brothers and sisters of US citizens. Those are the only family relationships that can sponsor. Grandparents cannot sponsor grandchildren. Aunts and uncles cannot sponsor nieces and nephews. This is it in terms of family sponsorship. Just like in the employment-based arena, there's a petition and an adjustment stage. They are nearly identical. The only differential is whether the sponsor for your petition is your employer or your family member. You'll note that the family sponsored process does not have a labor certification. It doesn't make sense in the context of labor certification. But the petition and adjustment stages are nearly identical for employment-based and family-based. There are also waiting periods because there are also quotas involved in the family-sponsored process. So the visa bulletin that we talked about before also has a family section. So final action chart for family-based cases. You'll see by way of example that if I am an adult child of a US citizen sponsoring me, I fall into FB1. Let's say I am from Mexico. That is backed up to January 15th of 1999. It is a very long process, 22 years for an adult for a U.S. citizen to sponsor their adult child from Mexico. So you just have to take a look at these numbers. Some people have employment-based options and also have family-based options. We evaluate all options available for individuals and make sure that we're following the best path. So just because you have a family member who may sponsor you, if you're in a category that's really significantly behind on the visa bulletin, we may recommend the employment-sponsored case if your employer is willing to sponsor you. And vice versa, if your employer is willing to sponsor you, but you've got a quicker family-based case, we may recommend that. And individuals can have more than one process going at a time. You can file different processes concurrently to see which one basically hits first. In the visa bulletin, there's both a final action chart and a dates for filing chart, just like we talked about in the employment-based arena. And that's really all I'm going to spend on the family-based. It's more important to evaluate these relationships. The only thing I will say about the immediate relative spouse category is that if you marry a U.S. citizen, you do need to make sure that it is a bona fide marriage, a real marriage, and not just a friend helping you out for green card. By filing those types of cases where it's not a real marriage, it is a federal crime. It's a felony. It's basically immigration fraud, and we counsel against it significantly because the consequences to you are going to far outweigh on the negative side any potential benefit. So just be cautious about those marriage-based cases. So then we are at closing thoughts. After this, we will answer your questions. As I mentioned before, while there are certain steps we follow in each case, no two cases are alike. Do not rely upon what you heard from your friends. Certainly take what they tell you into consideration, but don't let it determine your immigration path. You need to be well informed and determine your own path because it may be different or better than what your friend is describing. You need to be very transparent with your DSO, and if you have immigration counsel, with your immigration counsel. The advice that they can give you and that I can give you is based upon the information you share with us. If you hide information from us, you're not getting a full answer from us, and it could come back to bite you. Maintain copies of all your past, present, and future immigration documents. So for example, if you get sponsored for H-1B, I'm going to ask you for all of your I-20 forms. And all of your visa stamps and copies of your passports. If you send your passport in to be renewed, make a nice clear copy of every single page before you send it in. Keep your immigration file and keep it well. Make clear copies. If you make a copy of your passport and your face is all dark and we can't see your face, that's not a nice clear copy. 10 years from now, if you're sponsored for green card by your employer, we're going to still ask you for copies of all your I-20 forms. So you're going to have to reach back a lot of years to find those documents. So keep everything. Invest in your immigration future by educating yourself, not just on the internet, but definitely on the internet, but not just on the internet. Pay attention to your DSO. Take action timely. You and you alone are responsible for making sure that you maintain your status. And when appropriate, seek advice from competent immigration counsel. Competent immigration counsel is hard to define. It's kind of like you know it when you see it. The cheapest isn't always the best. The most expensive isn't always the best. Get comfortable with your immigration counsel because it's a years-long relationship that we have with our clients. Make sure that you're getting timely feedback. Cases don't always move quickly, so don't expect your immigration counsel to move your case next week. But make sure it's moved reasonably and thoroughly. So, and keep on top of what's happening. Ask for copies. You're entitled to copies. We have a portal that we post our clients' information in. So if we file your case is posted for you to see the next day. If your immigration counsel is not sharing those documents with you, you need to be concerned. So, but definitely at this stage with F1, your DSO is your best friend. So make friends, be nice, and keep them well informed. And that's all I have. So I'm happy to answer questions.
Okay. Thank you, Debra, so much for this amazing presentation. And let me see, we have about 12 questions. We're going to try to answer them to the best of the time that we still have. And the presentation will be, we recorded this presentation, so it's going to be available after everything is settled and done with. So let's see. I'm going to read the first one. Can we use CPT to work full-time? Full-time during the summer if we have a pending I-485 adjustment of status application, meaning that we have submitted an I-485 but have not received a new EAD card yet.
CPT, so they're still enrolled,
Yeah.
still in F1, and GMU does not terminate them in CVIS when they file a 485?
We do not. They can, unless they want us to.
Okay.
So,
As long as their F status is valid, the CPT is authorized, and they're not terminated in CVIS, then yes.
thank you, Deborah. I would actually said the same thing. I just left this one for you to see what your opinion was on it. So thank you very much. When should we ask our employer to file H-1B for us?
So that's a tough question to answer because it's going to be based upon your relationship with your employer. But I wouldn't surprise your employer with it on March 1st when the lottery opens. I would be upfront with the employer early on about the need for future sponsorship, plant the seed, grow the seed, work hard, do really great work, and make them want you to stay. That's the best thing you can do. And again, it's going to be based upon your relationship with your employer. Employers just don't like surprises. They don't like short-term mandates that they have to get something done without being warned. So I do have a lot of employers as clients, and I feel their frustration when they call me and say, I just got a call from this employee and they said that I have to do this and I have to do it by next week. And they're very, very frustrated with that. So I don't recommend that. I recommend that early open dialogue. Don't fixate on it. We have some employees that fixate so hard on their immigration process that the employer calls me up and wonders whether they're actually doing their job because they spend so much time during the day focused on their immigration stuff. So keep that in mind too. You're there to do a job, do it well, prove yourself, make yourself invaluable to them, and slowly plant that seed and grow that seed of sponsorship so that it's fully in bloom by the time March hits and the lottery opens.
Thank you. The next question is, if my husband who is on an F-2 visa gets a job offer, is it possible for him or the hiring company to apply for a work visa?
So he can certainly change status. He or she can change status from F-2 to H-1B or another qualifying work-based visa. But there's not just a generic work authorization for F-2s, except under very special circumstances that I will not go into because I don't really touch on them very much. But I will tell you that applying for F-2 emergency work authorization basically is not easy. It's not necessarily the best thing to do in terms of your F-1 status. So yes, if your spouse in F-2 qualifies for an H-1B, for instance, they already have that qualifying bachelor's degree and they found a job in a qualifying H-1B specialty occupation, and the employer wants to put them through the lottery and hire them and sponsor them for H-1B, absolutely.
Great, thank you so much. The following question is, after the 6 years of working on an H-1B visa, what is the process to attaining a green card? Can you self-sponsor after the 6 years?
Okay, so we spent a lot of time in this presentation kind of going through the green card process. You really should start that process well before you reach the 6 years, because there are only, if you have not done this before you reach 6 years, you're going home after the 6th year unless you do something different. So you max out on your H-1B 6 years. You might be able to change to some other status like an O. You might be able to go back to school in an F, but you cannot maintain that H-1B beyond 6 years if your green card case has not hit one of the 2 milestones to allow H-1B extensions beyond 6 years. You can self-sponsor for the green card under those 2 circumstances we talked about toward the end of the presentation.
Excellent. Another question is, if a company sponsors my H-1B visa, am I bound to that same company for the duration of my H-1B?
So when an employer sponsors you for H-1B, you may only work for that H-1B employer. If you wish to change to a new employer, your new employer can file a petition to transfer your H-1B from employer A to employer B. It's a change of employer petition, basically. So you're not stuck with the same employer for the full 6 years, but you can't change employers until new employer files to transfer your H-1B from employer A to employer B. Once that petition is filed, you may start with employer B. You do not have to wait for the approval of that transfer petition. You can start as soon as the government receives it and has it in their hands.
Excellent. So then what should we do if during the green card process, the OPT becomes expired?
So if your OPT is expiring, you need to be talking to your employer well before that about the H-1B process to take you from OPT to H-1B while your green card is in process. Unless your green card has reached the adjustment of status stage, the 3rd stage, then you don't get to stay by virtue of the green card process. If your adjustment of status is already filed, you may stay based upon that adjustment of status filing, and you may work if you've gotten work authorization through that adjustment stage and the work authorization is in your hands. You cannot work without the work authorization card being in your hand. It's not good enough to have applied for it. So if you're in green card, and let me presume you mean that your adjustment of status is filed, your OPT has expired, you may stay by virtue of the adjustment, but you must stop working until the employment authorization card is in your hand.
Thank you very much, Deborah. Another question is it possible to change the visa status from H-1B to EB-1 or EB-2 to get a green card?
So you wouldn't be changing from H-1B to EB-1 or EB-2. They are 2 separate things. So when you are in H-1B status being sponsored for green card, when the green card is approved, then you have your green card, and the H-1B and anything underlying the green card being placed in your hand dies. So if you have H-1B status and your green card is issued, H-1B is gone. It's not necessarily changing from H-1B to EB-1, EB-2. It's just I'm tinkering with the terminology that's being used. But yes, it's absolutely possible to be in H-1B status and be sponsored for green card in any category and get your green card.
Thank you. This one is from a current student studying in computer science, and he or she is wondering if their sister, who is currently a green card holder in the United States, can she sponsor them for a green card?
She cannot. If you go back to the family-based preference category slide, U.S. citizens may sponsor their brothers and sisters. So once she's a citizen, she could sponsor him. But before going down that path, this F-1 student needs to talk with counsel and understand what that means for him or her, because it may mean that there's no more travel outside the US, because the F-1 status is a non-immigrant status. To get H-1B, to keep H-1B, to enter the US, I'm sorry, F-1, get F-1, maintain F-1, enter the US and F-1, you must not have the intent in your head to immigrate to the United States. You must consistently demonstrate non-immigrant intent for F-1 status. So if this F-1 student is sponsored by his sister once she's a citizen and then departs and applies for a new F-1 visa stamp to return, he or she may not be granted that F-1 visa stamp. So yes, it is possible for her to sponsor him once the sister is a citizen, but have a better immigration plan in hand. Just don't do it willy-nilly. You need to have a long-term plan to do that.
Thank you so much, Deborah. I think we're almost out of time. There's 4 more questions left. I'm not sure how you wanna.
I'm okay. You're okay on time.
Huh?
I'm okay to continue if you want to. I'm okay on time.
Okay. So the next question is, I've heard that H-1B is considered as a dual purpose visa. Does this mean that the H-1B visa holder can get a green card right away without changing visa status?
So the H-1B is what we call a dual intent visa, not a dual purpose visa. Dual intent means that the person, so all of the temporary visas, the non-immigrant visas, the B, the F, H, L, E, O, all of the lettered visas that we talked about, TN, are non-immigrant visas, and they all require non-immigrant intent. You may not have the intent to immigrate to the United States and still maintain those visa status. The H-1B and the L are exceptions to the rule. They are what we call dual intent visas. So it is okay to be going through the green card process while in H or L, and you can still travel and you can still go get your H or your L visa stamp, because it's a dual intent visa. And what that basically boils down to is that you can look the government in the eye and say, yes, I want my green card. Yes, I'm applying for my green card, but I will comply with the terms of my H-1B visa. And if I'm told to go home, I will go home. That's what I have in my head. So that's what dual intent is. And H-1B does not lead to green card. It just is a status that allows you to be here while you're working on green card.
Thank you. So the next question is, first of all, the student is asking, would it be possible to connect at the end? I'm not sure if the presentation has your contact information and the students can contact you directly and schedule a meeting with you. But if there is, I would propose that would be done that way, I guess.
Yes.
Yeah.
Information is at the end. They are welcome to call the number. It's the main number. Lily is my assistant, and she would answer the phone in most cases and schedule a call or a Zoom meeting with me. It won't be today. I've already looked at my calendar. I know it won't be today, but they can schedule with Lily for another day this week or even into next week. If there are documents involved, they should present those documents to me by email or some other method. At least a day before the scheduled call, so I can take a look at them and be prepared for any call. But yes, I'm happy to connect, and they should reference the GMU presentation so that they're not told about a consultation fee or anything like that.
Okay, thank you so much. And then the next question is, can I work for more than one company with 2 different H-1B visas, or I'm only allowed to have one?
Okay. You can hold concurrent H-1B visas that allows you to work for each of the sponsoring H-1B employers. Obviously, you're not likely to file for 2 full-time H-1Bs, and H-1B can be part-time. So you're likely to hold either 2 part-times or 1 full-time, 1 part-time. but the government will start to look a little askance at you if you're filing for 2 full-time H-1Bs. But yes, you can work for 2 H-1B employers. You may not work for anyone who's not your H-1B sponsor. So if you have 2 H-1Bs, work for those 2 employers, not a third company. So, and I've never seen 3 concurrent H-1Bs approved at the same time. Not saying it's not possible, but I've never seen it.
Thank you, Deborah. I can't even imagine somebody working for 3 employers. I mean, that's how many hours a week? That's impressive. And final question, thank you so much, is research paper publication a requirement for NIW?
There's no single requirement, but in order to show NIW, you're going to have to show that you are working in a field that has substantial intrinsic value to the United States, and that your contributions to that field outweigh the requirement for a labor certification. So we do that often by showing the work that the person has done. We show the work the person has done and the contributions that they've made by showing a variety of things, publications, patents, invited speaker, membership in organizations that require some sort of advancement in the field in order to become a member, prizes, awards, honors. It's very similar to the EB1 cases for outstanding and extraordinary. So I'm not going to say that a publication is a requirement if there are enough other factors that would sway the examiner in the case. So it's not an absolute requirement, but I would be hard pressed to find someone who would qualify for NIW without at least something out there like that.
Excellent. Thank you, Deborah. I think we're done with all the questions. This was an amazing presentation. I hope everybody who listened to it, got to really experience and appreciate what you did for us today. This was incredible.
Thank you.
I think that unless my colleagues have anything else to add, I think we're ready to just wish you the best and have a great day. And thank you so much for doing this. This was
Thank you. I
amazing.
enjoyed it very much. Thank you for inviting me.